Danger of AI-generated business contracts. The rapid adoption of generative AI for drafting business contracts presents a deceptive allure of efficiency that often masks profound legal and financial hazards. While these tools can produce documents that appear professional and authoritative, they operate on probabilistic patterns rather than a true understanding of legal principles or the specific commercial intent of the parties involved. Relying on AI without the deep involvement of a knowledgeable lawyer creates a structural vulnerability where a company may unknowingly agree to lopsided terms, waive essential rights, or leave critical risks unaddressed. Even when a lawyer performs a cursory review, the speed and volume of AI output can lead to a dangerous dilution of professional diligence, allowing subtle but catastrophic errors to slip into the final execution. One of the most insidious dangers is the phenomenon of AI hallucinations, where the system generates plausible-sounding but entirely fabricated legal citations, statutes, or precedents. For a business, this can result in a contract that references non-existent laws or relies on outdated legal frameworks that have since been overturned or amended. A cursory review by a lawyer, often treated as a mere rubber stamp, may fail to catch these fabrications if the reviewer assumes the underlying research is sound. If such a contract is challenged in court, the discovery of fabricated terms can lead to the entire agreement being deemed void or unenforceable, leaving the company with no legal recourse during a dispute. AI models are typically trained on vast heterogeneous datasets that may prioritize jurisdictions like Delaware or New York or Ontario when it comes to Canadian legal matters. Consequently, an AI-drafted contract may inadvertently include market-standard clauses that are strictly prohibited or unenforceable in the actual governing jurisdiction, such as overly broad non-compete agreements or invalid indemnity waivers. Without a lawyer's granular knowledge of local statutes, regulations, and court precedents, a company might sign an agreement that is dead on arrival. The financial fallout from such a mismatch often includes heavy regulatory fines, lost litigation, and the total loss of the protections the contract was intended to provide. Legal drafting is not merely a linguistic exercise. It is a strategic tool designed to allocate risk based on a company's specific risk appetite and business model. AI lacks the cognitive capacity to understand the nuances of a particular deal, such as the strategic importance of a vendor or the specific intellectual property vulnerabilities of a startup. An AI might generate a standard limitation of liability clause that is technically legal but commercially disastrous, such as failing to cap damages for a high-risk service or omitting essential carve-outs for gross negligence. When a lawyer is not deeply embedded in the drafting process, these misalignments go unnoticed until a breach occurs, at which point the company faces uncapped financial exposure that could have been easily mitigated by human foresight. A critical distinction between utilizing a human legal professional and an AI tool lies in the near-universal presence of broad liability disclaimers within AI service agreements. Unlike a law firm that carries professional indemnity insurance to protect against drafting errors, AI providers explicitly state that their outputs are provided as is and without any warranty of fitness for a particular legal purpose. This shifts the entire burden of risk onto the company, which often lacks the specialized training to recognize when a generated clause is subtly flawed or legally catastrophic. Consequently, the company finds itself in a liability vacuum where it is 100% financially responsible for any contractual failure, with no possibility of seeking recourse from the technology vendor. This lack of an insurance safety net means that a single machine-generated oversight can result in a direct hit to the balance sheet from which a business may never recover. Furthermore, the quality and accuracy of an AI-generated contract are almost entirely dependent on the quality of the prompt or input provided by the user. Most business users are not trained in legal engineering and may fail to provide the AI with the necessary context, such as specific regulatory requirements, complex payment milestones, or nuanced indemnification triggers.
When the user provides incomplete or vague instructions, the AI simply fills those gaps with generic, hallucinated, or mismatched terms that do not reflect the true intent of the parties. Many of the most expensive errors in these contracts can be traced directly back to this garbage in, garbage out dynamic, where the company unknowingly creates its own financial trap through imprecise inputs. Because the AI cannot ask clarifying questions like a seasoned lawyer would, the resulting document often lacks the precision required to withstand a serious legal challenge. Contractual disputes are frequently won or lost on the interpretation of a single word or the placement of a comma, and AI is notoriously prone to creating hidden ambiguities that surface only during litigation. Because AI-generated text often lacks internal logical consistency across 50-page documents, it may include contradictory obligations in different sections that a human lawyer would have caught during a focused manual drafting process. Under the legal principle of Contra Proferentem, courts often interpret such ambiguities against the party that drafted the agreement. If a company presents an AI-generated contract to a partner, they effectively become the drafter, meaning any machine-generated vagueness will likely be weaponized against them in court to their significant financial detriment. Drafting a bespoke contract often requires inputting sensitive business data such as pricing structures, trade secrets, or proprietary workflows into the AI prompt. Most consumer-grade AI tools do not offer the same solicitor-client privilege or stringent confidentiality protections that a law firm is ethically and legally bound to provide. By feeding proprietary deal terms into a third-party AI, a company may inadvertently waive its trade secret protections or violate existing non-disclosure agreements with other partners. This exposure can lead to the loss of competitive advantages and potentially trigger third-party lawsuits for breach of confidentiality, creating a secondary layer of financial liability that exists entirely outside the four corners of the contract itself. Ultimately, the perceived cost savings of using AI for contract drafting are often an accounting illusion that ignores the massive back-end costs of legal cleanup or litigation. When a dispute arises over an AI-generated contract, the legal fees required to interpret, defend, or reform the flawed document often far exceed what it would have cost to hire a lawyer to draft it correctly from the start. Furthermore, the reputational damage of being seen as a lazy or unprofessional counterparty can alienate strategic partners and investors who view the reliance on unvetted AI as a sign of poor corporate governance. In the eyes of the law and the market, there is no substitute for the nuanced judgment and ethical accountability of a human legal professional. To learn more about our law firm's corporate business and contract legal practice, we welcome you to visit our website and contact our law firm to schedule an initial consultation. Thank you.